It must have been some experience for the attorney representing Harris Teeter, the grocery retail chain, at a trial to defend Harris Teeter in the face of over 25 citations issued by the North Carolina Occupational Safety and Health Administration, comprising inspections at 5 different establishments. A compliance safety and health officer testified at trial that all of the officers involved in those inspections shredded their field notes after having transferred what they thought was the essence of those notes into the official inspection file. At that point in the trial, the judge learned that 3 pages from only one of the 5 compliance officers' field notes had not been shredded. These field notes contained notes from interviews with on-site witnesses during the inspection. At that point in the trial, Harris Teeter's attorney must have wondered what was in these witness interviews or witness interview notes that were destroyed. The attorney for Harris Teeter sought to find out. What he discovered and how the judge treated this document destruction is the topic of our discussion on this March 2025 episode. I'm Manesh Rath, and this is the OSHA 3030. Well, hello, everyone, and welcome to the OSHA 3030. As I said, I'm Manesh Rath. I'm an attorney at the law firm at Keller and Heckman, LLP, here in Washington, D.C. The OSHA 3030 is a program we've been doing over a dozen years, where in about 30 minutes, we cover developmental issues in the field of occupational safety and health law every 30 days. Another 30, I've been representing strictly management in the field of occupational safety and health law and other related areas for the past 30 years. You can find out more about me on our firm's website, khlaw.com. Another person whom you can find out more about on our website, who's joining me today, and I'm very grateful you're joining me today, my friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030.
Thank you, Manesh. It's great to be here, as always.
Well, we have, I must say, maybe one of the most fascinating decisions to be handed down in the field of occupational safety and health law in as long as I can recollect. So I think we should get right into it, Ben. A valued part of our occupational safety and health team, but also a part of our environmental law and transportation law teams. What did you think of this case?
Fascinating case with big implications for, I think, the Occupational Safety and Health Department of North Carolina and ones across the country.
Yeah, I agree. For practitioners and for agencies across the country, as well as U.S. OSHA, to take heed of the logic set forth by the administrative law judge in this decision and the arguments from both sides. So with that said, let's go ahead and talk first about what we're going to talk about today.
Right. So we're going to, as always, begin with the facts of this case. And next, we're going to discuss the discovery and I think also the pre-trial stage and the trial stage, which I think the events of this particular case center on.
Right. And Ben, I think we should talk about the applicable law as to exchange of documents next.
Right. Then we're going to get into the arguments that were made by Harris Teeter and then also the arguments that were made by NC OSHA.
And finally, we ought to go in depth into how the administrative law judge found those arguments and what his holdings were in this decision.
That's right. And we're going to conclude, as always, with practical tips for the employer community.
That's right. And this is a pre-recorded episode for March 19th, 2025. We usually, for live programs, have a off-the-record section where you can submit questions. We still encourage you to submit questions to us by email. We love chatting about this stuff. So if you have a black letter law, question of law about OSHA law, or any other related area of workplace law, we'll take a hand at it because this is always interesting stuff. And what's on your mind, the kind of questions that are on your mind are always of great interest to us. So we love hearing from you. With that said, let's go ahead and get cracking on the facts in this case. So it starts off with North Carolina OSHA conducting inspections at several Harris Teeter establishments. I think 5 establishments in this case.
That's right. And those inspections led to over 25 citations being issued.
Right, 27. And this isn't really part of the judge's opinion. This is on deep background that you see that before this decision even starts, there were these inspections at 5 establishments and that they were consolidated for a single hearing. And then by the time this decision starts, the hearing has essentially begun, and the attorney for Harris Teeter finds out for the first time in the hearing, according to the administrative law judge's opinion, that there were these other documents that he's never seen that are being referenced by a witness who's testifying at the hearing. So these cases were consolidated, 27 citations. Harris Teeter contests the charges, goes through discovery, and then goes into the hearing itself.
Right. And the beginning of the hearing, Harris Teeter, prior to the hearing, I should say, asked for the official inspection report, which under the North Carolina Occupational Safety Act, they have to provide within 10 days of the hearing.
And they did provide an official inspection file. Then the trial begins. North Carolina OSHA did not supply, as part of that official inspection file, any underlying field notes. For example, notes taken by compliance safety and health officer when interviewing on-site witnesses.
Right. And this obviously raised the question of what happens to those notes. And the judge in this case asked, and North Carolina OSHA responded by saying that these notes are shredded once the inspectors place them or their contents, or a relevant portion of their contents, into the actual inspection report.
Right. And it comes up at trial when the attorney for Harris Teeter is listening carefully to the testimony of one of the compliance officers. And the compliance officer is talking about witness interviews that he conducted. And when asked where are the notes for those witness interviews, this is when he reveals for the first time, oh, we shred the notes that we take during witness interviews. And the essence that we think is relevant is reduced into the official inspection file. And we produced that to you. If any element of the witness notes was not transferred into the official inspection file, it's because we thought it wasn't really relevant to the case. So the judge asked, well, these notes that were shredded, why were they shredded? What happened? When did they get shredded? It turned out that the compliance officer, there's 5 compliance officers inspecting at 5 different establishments. And Ben, help me recollect, but the one compliance officer that produced some notes, maybe errantly, maybe as an oversight, included 3 pages in his production of field notes that had notes of witness interviews.
Right. And Harris Teeter at the hearing got an opportunity to see a portion of those notes, and as you mentioned, wondered where are the rest.
Right. If those 3 notes, those 3 pages of notes of witness interviews survived from this one compliance officer, maybe by accident, were there other notes by the other compliance officers or by even this compliance officer? Why were there no other notes at all from any other compliance officer? And what else could have been in those notes? And this is interesting because the compliance officer then, it was scanned by his own attorney, by the attorney for North Carolina OSHA at that juncture. And then afterwards, North Carolina OSHA promptly shredded those 3 pages as well, saying, well, this is our standard protocol. Since we shred all notes, now that we discover that these 3 pages didn't get shredded, we're shredding them too. And so this left the judge with documents that he knew existed at the time of the hearing. Harris Teeter's complaint, to be clear, is that there were documents pre-hearing during the discovery stage that it had asked for and never received that were shredded. And then now we're at the hearing and there's 3 more pages that survived that the judge now knows exist that now get shredded after they get described and examined at trial, and that the North Carolina OSHA attorney has had an opportunity to scan. So the judge examines those 3 pages. This is, I think, a fascinating development in that moment in the trial where the North Carolina OSHA has now acknowledged that it had shredded, as a matter of routine, all underlying notes once they were transferred in salient part, according to them, into the official inspection file. And what I think is fascinating about that is 10 days prior to the trial, there was an exchange of documents, a pre-trial exchange of documents, including the official inspection report, and it contained none of this.
Right. And that's sort of the argument that North Carolina OSHA makes, is that we followed the letter of the law. We provided the official inspection report, and the notes. Well, the contents of our notes are in the official inspection file. But I think
if they were relevant.
right, and that's the big problem here is that how can the employer, trust that all the relevant information from the notes was actually put into the inspection file?
Right. I've handled many trials, and relevance determinations are an ongoing debate in every case, all throughout the trial, all throughout pre-trial motions practice, and all throughout discovery. The parties are constantly debating what facts are relevant, what facts are not relevant. So for North Carolina OSHA to make that decision unilaterally came as an incredible surprise, both to Harris Teeter's attorney as well as to the judge.
Mhm.
So let's talk about the four primary sources of law that I think operate upon the judge's thinking in this case at this juncture in the hearing. The first is by matter of rule, practice, a rule of practice, the parties have to exchange 10 days prior to a hearing all documents, including North Carolina. OSHA has to exchange the official inspection report. Another law that's applicable here, and Harris Teeter argued was applicable, is a law referred to as the North Carolina Public Records Act. It is not terribly different from public records acts, both at the federal level and in states around the country. So it's relevant nevertheless, even though it's a state-specific law called the North Carolina Public Records Act. And it essentially holds that agencies, state agencies, are required to preserve public records.
And the third major point here was the field office manual, which in this situation was only guidance. It wasn't an actual applicable law, but given the facts, the judge and the parties cited to it often. And what the relevant portion of the field office manual said is that all notes that are recorded are required to be noted in the worksheet or attached to it, to the violation worksheet.
Right. And so let me explain what the field office manual is. In the simplest form, it is a statement from the head of the agency or the agency itself to area directors or inspectors by indirectly as to how to conduct inspections, how to maintain their enforcement practices generally. And so essentially the agency is telling the area offices and by extension all the compliance officers what its interpretation of right, proper procedure is. And as you say, Ben, one of the things it says is that all notes shall be recorded on the violation worksheet or should be attached to the violation worksheet. Finally, North Carolina's rules of evidence. These are the rules of evidence by which the parties debate what's relevant, for example, what's admissible. And one of the rules of evidence in North Carolina's rules of evidence says that the parties must make underlying data available to the opposing side. If you prepare or submit or have in possession a report or a summary of any kind, a table, a chart that is a summation of data, then the underlying data has to be made available to the opposing side. So those four rules, Harris Teeter argued, are all in effect at this moment in the trial when it's discovered that North Carolina OSHA, as a matter of routine, shreds all underlying data, the witness interview notes in this case, or other field notes, and says that these are the four rules that North Carolina OSHA knew it was obliged to and needed to comply with and did not.
So when we get to Harris Teeter's argument, I think we discussed earlier, Manesh, how I think it boils down really to a question of due process. Without these field notes, Harris Teeter would be unable to adequately prepare to cross-examine its accuser, NC OSHA, and would be unable to function without the underlying notes.
Yeah, Ben, I think that's right. I mean, the due process concept is a broad concept, but it certainly includes the idea that an enforcement agency should disclose all evidence that's relevant when bringing an enforcement action against a citizen like Harris Teeter. And so Harris Teeter's argument was, how are we to effectively prepare for trial, and how are we effectively expected to effectively defend against charges brought against Harris Teeter when being prevented from seeing all of the evidence that the compliance safety and health officer has obtained or possessed. And I think that that is a argument that resonates under this idea of due process and the right to face your accuser, but in addition, to test the statements being made by a witness through cross-examination. That when a compliance officer gets on the stand and says, well, I spoke to a witness who told me X or Y or Z, to be able to validate or test the reliability of that assertion because perhaps the underlying notes revealed something slightly different, a slightly different interpretation of what the maybe the witness might have said. And without those notes, Harris Teeter argued it didn't have the means to effectively cross-examine a compliance safety officer about what he saw, observed, or heard from witnesses. So that's Harris Teeter's argument. North Carolina OSHA has plenty of arguments in response, and I think we should go through all of them in order to better understand how employers should conduct themselves through citation contests in the future.
Right. So the first argument that NC OSHA makes is that, we followed the letter of the law here. The statute requires us to provide the official inspection report 10 days prior to the hearing. And the statute also requires, as we'll discuss later, that if formal witness statements are taken, that they also be provided. But no formal witness statements were taken in this case, so they had nothing to provide.
Yeah, that's right, Ben. I mean, I think the first thing that North Carolina OSHA tried to urge upon the judge was, hey, look at these citations. These are North Carolina OSHA argued properly issued. These are real violations, they argued. And so this is just a technicality, a procedural issue that Harris Teeter is unjustifiably seizing upon to steal the attention away from whether or not there was a violation. And you, the judge, should focus on the ultimate question of this trial. Were these citations properly issued or not? Were there violations of the North Carolina OSHA standards or not? And not on these technicalities about what we produced and didn't produce and what we did with underlying notes. So that's the first argument. The second is Harris Teeter had pointed out that there are rules going to the requirement that documents in the public record have to be preserved. North Carolina OSHA said, well, these aren't documents in the public record. These are the private notes of the compliance officer, so they're not in the public record. Not only that, North Carolina argued, these are transitory documents. They're sort of maybe the underlying draft. And you can throw away the draft once you've created a final draft. And that's all we did, North Carolina OSHA argued.
Right. And then finally said that anything that they did claim that if the inspectors believed that whatever was in their notes wasn't relevant, that they had no duty to transfer it into the official report. So they only transferred as they required what was relevant to put it into the official report.
Right. I think that's one of the most interesting arguments that North Carolina OSHA argued is that we have these long notes, and if some of it's irrelevant, sometimes most of it's irrelevant, we don't put that in the official report. We decide, and we alone get to decide what goes in the official report, and we get to make relevancy determinations based on what's relevant to us. They also had another argument that they said, Judge, we, as a practice, North Carolina OSHA has been shredding the underlying field notes for decades, since the beginning. Once a field note has been reduced, or at least its relevant portion has been reduced to the official inspection report, there's no need to keep those underlying notes. Those are the draft copy, and so we've been shredding that for decades. There's never been any problems with that before. Mm-hmm. That's one of the arguments North Carolina OSHA made.
Right. And to build on that point, I think it was interesting that it came out that this seems to also be a practice in other states. And I think Tennessee was the one that was mentioned. So curious to see if this case will have ripple effects in the volunteer state.
Yeah, certainly Tennessee should be looking carefully at this decision, and any other state where this is a common practice, but certainly at the individual level, any compliance officer who has out of an idea of this being normal has engaged in this practice. I think this is an important opinion for them as well. Mm-hmm. Indeed, the chief of staff for the North Carolina Department of Labor testified that data in field notes, such as notes about observations or witness statements, only are relevant if they support North Carolina OSHA's 4 elements that it has to establish. Recollect, in prior episodes of our OSHA 3030, we've talked many, many times about the 4 elements OSHA has to establish when alleging a violation of a standard, and a different 4 elements that OSHA has to allege when alleging a violation of the general duty clause. And so as to these 4 elements that OSHA has to establish when alleging a violation of a standard, the chief of staff of the North Carolina Department of Labor said field notes, to the extent that a specific note supports one of those four elements, that's relevant and that's preserved in the official report. But if it's merely supportive of the employer's affirmative defenses, that can be destroyed and does not need to be preserved in the official report. That testimony I find to be incredible and of great interest. His view was that A, North Carolina OSHA can make its own relevancy determinations as to what goes into the official inspection report. Oh, and by the way, B, if it's relevant to the defense or affirmative defenses, then it's not relevant to us and therefore won't go into the official inspection report. Moreover, it can be destroyed, lost forever. So that was the position of the chief of staff of the North Carolina Department of Labor, Ben.
Right. And just to wrap up on the defenses here, NC OSHA also stated that, again, like we discussed, that they did not take formal statements. And a formal statement is one that the statute does require to be produced to the opposing side. But NC OSHA said that we didn't do it in this case. They noted how they didn't use a particular form that is traditionally used to take formal witness
Right.
statements.
It's just the inspector's notes
Right.
of a conversation with a witness.
Right. So they were saying that they had no duty to produce. And they also, I think, made a practical argument as well, saying that it's difficult, with sort of how quickly inspectors have to be on a property. They can't have all the time to take these formal statements. And one of the things they mentioned is the language barriers can cause issues.
Well, generally, all three of their arguments on this point went to the idea that if they take witness statements during an inspection, they would go back and have to type it up into a formal statement and then come back to the establishment to get it signed. And what they said was, you're right. They said one of the problems with that is sometimes, not every time or even most of the time, but sometimes that would require language translation. If the witness was not fluent in English, then it would require language translation, and that's costly and burdensome. The other argument they said about making turning witness notes or notes about witness statements into a formal statement was that sometimes it's difficult to get the employee back off the line a second time to read their formal statement and to sign their statement. Right. Never you mind that the North Carolina Occupational Safety and Health Compliance Officer pulled that employee off the line to take their statement in the first place. Now, spontaneously, it's too burdensome for the agency to pull them off the line a second time merely for reading and signing their statement. Right. And that's their second argument.
Yeah, and the third, they mentioned that employees have concerns regarding their privacy, their confidentiality. Having to sign their name into a certain statement might be difficult for the inspector to do, as opposed to just sticking with maintaining their field notes.
So I think what this argument boils down to is that North Carolina OSHA is saying, I want to take witness statements in my own handwritten notes and then shred them. And one of the reasons is I want to protect the employee's confidentiality. So if I produce to you, the employer, all of the underlying observations that allowed me to form a conclusion that that violation existed, I would be revealing the confidentiality of the employees. And some of the employees may not want their confidentiality revealed. And so I will speculate that all of them don't want their identity revealed. And so I'll shred all notes. And that is a justification for why formal statements wouldn't be taken. Because if I took it and converted it into a formal statement, then they would sign it and it would become a part of the official record and it would be produced. And then some of the employees who didn't want their identity revealed would have those identities revealed. That I think that belies the easier solution, which might be to redact the employee's identity in production stage. In other words, they could have still taken a formal statement and then when asked to produce it, redacted the identity of the employee witness, if indeed the employee witness hoped to remain confidential. Right. But some of these employees were actually witnesses at trial, or were called, or were listed as potential witnesses at trial. And at that juncture, their identity is impossible to conceal, and the employer should be entitled to conduct a cross-examination. So their identity, preserving the confidentiality of their identity, is in the end somewhat of limited value if indeed they get listed as a witness or as a potential witness. So those arguments are troublesome to begin with. Right. So the administrative law judge heard all of North Carolina's arguments, Harris Teeter's arguments.
Yeah, and I think it boiled down for him, it seemed like, is that this idea that these notes don't have any evidentiary value was not true. They do have tremendous value because they underpin the official report, which is the basis of the citation.
Indeed, those three documents, those 3 pages that were accidentally preserved by one compliance officer, the judge examined those and said, well, I do think that there is significantly relevant information in those 3 pages, which is evidence that field notes can
Right.
contain relevant information not found in the overall official inspection file.
Right. There's also discussion about the argument that NC OSHA made in terms of these notes being transitory, and they mentioned how the definition of transitory requires it to be at minimal evidentiary value. So they said that did not apply. Another argument related to this that they discussed was how within the Public Records Act, the definition of drafts and working papers, which the NC OSHA said applied to these field notes, that did not require it.
Maybe not completely reduced to the official inspection file. So the field notes had some elements that were reduced to the official inspection file and other elements that were not, and
Right.
thus they were not merely drafts of a final report, right?
Right.
Yeah, and I think that that's important to consider when considering whether or not North Carolina OSHA should be credited in labeling these as merely transitory. The judge said they're not transitory; they're distinct documents all to themselves. They don't get reduced to a final draft if they're not entirely transferred. And then he points to the North Carolina Public Records Act again in a separate holding that when it comes to agency inspections, no destruction of records may take place if the agency believes that litigation is pending or is reasonably anticipated. If an agency thinks that litigation is pending or reasonably anticipated, it may not destroy any records. And that seems to me not only reasonable for the judge, but consistent with all rules of discovery and court holdings and expectations of litigants when it comes to the preservation of records. So let's talk about some other of the judge's holdings.
Right. The judge discusses how, the need to preserve these field notes is apparent because they contain observations made by the investigators at the time of the investigation. So again, goes back to this idea that the employer has to be able to see these records to be able to test the case, the sufficiency of the field report, which is the basis of the citation.
Right, right. Statements by the witness the judge held that the agency intends to call or who might be able to support an employer's defense have to be produced in that 10-day exchange of documents. And the other thing the judge said was, I think you're pointing out, only the defendant is well positioned to determine what's relevant to the defendant.
Right.
And that is the whole point of the exchange of documents, is that it is not for the agency to say, you don't need these documents because I don't think they're relevant for you.
Mm-hmm.
If left to that kind of standard, nobody would ever get any valuable documents.
Right. And just to go full circle, I think the judge concludes that the strongest argument here against NCO shredding of the notes deprived the employer, Harris Teeter, of their due process rights.
Right.
And
the ability to see what evidence would have helped it and the ability to use it to cross-examine witnesses,
Right.
fundamental to due process.
Fundamental. And the court cites the cases, including the Supreme Court case and a case out of the Occupational Safety and Review Commission on the federal level that point to the same thing, where a defendant, an accused, has a right to examine the documents that will be used against them in testimony.
Consequently, the judge stated that he had no choice but to dismiss all of the citations in all of the cases. 27 citations dismissed because Harris Teeter had no opportunity to effectively defend itself. This is fascinating. This is a fascinating outcome that the entirety of the case, 27 citation items, were dismissed because of a failure to honor the employer's due process rights. So let's talk about what employers should do in light of this decision, the Harris Teeter decision.
Right. So I think the first thing to do is to make sure that you promptly issue document preservation requests to the agency.
Yeah, that's critical. And in discovery, repeat that request in the form of a discovery request and specifically request field notes witness statements, notes about witness conversations, any observations, imaging, recording. That should happen in discovery stage.
And then also ensure that you request a catalog of the documents that are in the inspection file. Try to gather as much information as to what the agency possesses in its totality, past and present, to understand what the case is, what the facts behind the case against you are.
Yeah, and then maybe even ask, in light of the Harris-Teeter decision, when you talk about past or present, ask if there were any documents that used to be in their possession that are no longer in their possession, any documents that have been destroyed, any documents that have been lost. I think it's important when talking to the compliance officer in discovery at a deposition to get the compliance officer to provide a detailed description of their entire inspection process. Try and find out whether they spoke to witnesses, whether they took notes during those witness conversations, whether they have any recordings or imaging, what measurements they took, what instruments they used to take those measurements, whether those instruments were calibrated. Every detailed fact that you can find out about the inspection process will be helpful in identifying what information is out there that the employer has to assess in order to identify whether to contest a citation and what defenses to select in order to make a reasonable defense for the employer.
Yeah, and also I think important to, request that the agency provide underlying data in the full form without being redacted merely because it can identify some individuals in the file.
Yeah, I think that's right, Ben. It's fair to expect that at discovery stage that the name of an employee be redacted, but sometimes compliance officers can be more aggressive on that and say that the statement made by a witness should be redacted also because it can be deduced as to who the witness was based on the statement itself. And I don't think that's fair. The underlying statement made by a witness is data that should be produced unredacted. And the name of the witness, at least at the discovery stage, OSHA has consistently maintained should be redacted. I don't agree, but that has been their consistent practice. But at the minimum, the data being sponsored by that witness, being testified to by that witness, should be produced unredacted.
Right. And then also make sure that you use motions practice or your counsel use an effective motion practice to push for the lessons that we learned from this case to ensure that the data that's provided behind a citation it's fulsome. You understand what is actually being charged against you.
That's right. I think that it's important to make sure that the employer has a fair opportunity to properly defend itself. And part of that is motions practice. And there's many stages at which motions practice can be applied here. If in discovery, an employer is not getting the data it needs and deserves to mount a fair defense, then it can ask for a motion to compel. It can ask for a motion in limine to exclude evidence based on what has and has not been produced. A motion for the judge to make an adverse inference is a reasonable motion, and Harris-Teeter did raise that motion in this case. And finally, a motion to dismiss if all other avenues of redress have not availed the employer in its pursuit of a fair trial, then the employer has to consider a motion to dismiss as well. The last thing I'd say, Ben, is it's important for the employer at all stages, even pre-notice of contest, to conduct as many witness interviews of its own as possible. Not knowing who are witnesses to the compliance officer during the inspection and during the pre-trial stage, it's important to conduct the employer's own interviews of witnesses to try and find out as much information as possible. This will help the employer in determining whether or not even to contest the citation in the first place, but contesting it, what defenses are reasonable defenses and should be pursued. That comes from a thorough investigation of the employer's own, including witness interviews. Well, Ben, that's it for today's OSHA 3030. Thank you all in our OSHA 3030 community for participating in another episode of the program. Ben, thank you very much. I'd also like to thank all of the staff on our team here at Keller and Heckman for putting together another program. We'll be back next month, April 16th, 2025 at 1 p.m. Eastern Time for another episode of the OSHA 3030. We have sister programs some of you may know about. If your organization is responsible for complying with REACH or with TSCA, you should know that the next episodes of the REACH 3030 and the TSCA 3030 are on April 9th at 10 a.m. and 1 p.m. Eastern, respectively. Great programs by some incredibly talented REACH and TSCA attorneys. Check it out if your organization finds REACH or TSCA relevant. Next month. We look forward to seeing you then. We look forward to staying in touch in the meantime. If you have any other questions, remember when you get the invitation for the next episodes to forward it on to at least 3 others within your organization and at other organizations who are safety and health professionals or in the office of in-house counsel, office of general counsel of your company, in order to extend the good educational services that we're providing gratis here at Keller and Heckman. We look forward to seeing you then. And until next month, stay safe.